อ้ยพี่อ้อยพี่ชอตไม่อยู่ยึดห้องจัดรายการเป็นของเราคนเดียวแฮปปี้ครับ
ก็ได้โอ้ยอะไรกันเนี่ยแค่นี้นะ
อะไร
ลม
เนี่ย
เสีย
อารมณ์เสียโวยวายเสียงวีนมาแต่เช้าเลยเธอ
จะไม่ให้ฉันวีนไม่ให้ฉันเหวี่ยงได้ยังไงจ๊ะจ้างช่างมาต่อเติมบ้านนี่เลยสัญญาส่งมอบมา2 เดือนแล้วยังไม่เสร็จเลยแล้วไงรู้ปะทำผิดแบบอีก
เอาก็ให้เขาแก้สิ
อ้าวแล้วพอบอกให้ลื้อไงลื้อไปทำตามแบบจะมาคิดตังค์ฉันเพิ่มบ้าหรือเปล่าคิดตังค์เพิ่มอะไรไม่ได้นี่นะถ้าไม่ใช่คนรู้จักแนะนำมานะฉันจะฟ้อง
เดี๋ยว
ขึ้นโรงขึ้นศาลให้เข็ดไปเลย
ไอ้ขึ้นโรงขึ้นศาลแล้วฟ้องเนี่ยได้ยินมาเยอะแล้วมันอาจจะสะใจแต่ถ้าทำไปจริงๆนะเสียเวลาเสียเงินเสียทองเยอะมากและบางทีคดีจบคนไม่จบนะ
แล้วให้ทำไงอ่ะ
ผ่านอะไรมาเยอะมากขอให้เชื่อมีทางเลือกมีทางออกสนใจปะล่ะ
เฮ้ยสนใจ
ทางนั้นสถาบันอนุญาโตตุลาการหรือว่า THAC เนี่ยเขาเปิดให้บริการระงับข้อพิพาททางเลือกซึ่งง่ายๆเลยคือเขาก็จะเชิญคู่กรณีทั้งสองฝ่ายหรือคนที่มันทะเลาะกัน2ฝ่ายนี่นะ
สมมติฉันทะเลาะกับเพื่อน
มาเจอกันแล้วก็ตั้งบุคคลที่3มาเป็นคนกลางในการประนอมหรือว่าจะทำหน้าที่เป็นอนุญาโตตุลาการเลยก็ได้ก็คือวินิจฉัยชี้ขาดไปเลยว่าเรื่องนั้นเนี่ยใครถูกใครผิดพอได้ข้อสรุปข้อยุติที่ชัดเจนก็ปฏิบัติตามข้อตกลงนั้นกันไปซึ่งวิธีนี้เป็นวิธีที่เขานิยมใช้กันทั่วโลกแบบเป็นสากลเลยทั้งคดีแพ่งแล้วก็คดีพาณิชย์เพราะอะไรรู้ป่ะ
เพราะอะไร
เพราะว่ามันสะดวก1 2มันประหยัดเงินประหยัดเวลารวดเร็ว
มีอีก
มากกว่าเวลาที่เธอจะต้องไปขึ้นโรงขึ้นศาลซึ่งโอ้ยขั้นตอนมันเยอะมากเหนื่อยมาก
จริงๆแล้วก็ยังรักษาความสัมพันธ์ที่ดีไปด้วย
ถูกต้อง
แต่ประเด็นก็คือฉันจะไปหาบุคคลที่3มาจากไหน
นั่นแหละเป็นเรื่องที่ยากที่สุดแต่มีคำตอบให้
ครับทางสถาบันจะมีการขึ้นบัญชีบุคคลนะครับที่มีความเชี่ยวชาญและมีประสบการณ์ในด้านการระงับข้อพิพาททั้งทางด้านอนุญาโตตุลาการและการประนอมข้อพิพาทนะครับโดยในบางครั้งทางสถาบันจะมีการฝึกอบรมนะครับผู้เชี่ยวชาญหรือผู้ที่มีประสบการณ์นั้นเพื่อให้แน่ใจว่าผู้ที่มาทำหน้าที่เป็นอนุญาโตตุลาการหรือการประนอมข้อพิพาทจะสามารถทำการระงับข้อพิพาทให้กับท่านได้เป็นอย่างดีครับ
สะดวกนะประหยัดด้วยสามารถยุติข้อพิพาทได้อย่างรวดเร็วดีอ่ะ
ไม่ว่าจะเป็นเรื่องเล็กระดับบุคคลปัญหาการค้าแบบ SME หรือว่าข้อพิพาทระหว่างประเทศก็สามารถให้สถาบันอนุญาโตตุลาการหรือว่า THAC ช่วยได้หมดเลยนะครับ
หรือจะโทรมาสอบถามก่อนก็ได้นะคะที่เบอร์ 02-018-1615 หรือ www.thac.or.th หรือ Facebook THAC จะมีเจ้าหน้าที่ยินดีให้คำปรึกษาเบื้องต้นแล้วก็ขอให้คำแนะนำฟรีตลอดเลยค่ะ
วันนี้เรา2คนลาไปก่อนนะครับสวัสดีครับ
สวัสดีค่ะ
โอ้ยพี่อ้อยพี่ชอตไม่อยู่ยึดห้องจัดรายการเป็นของเราคนเดียวแฮปปี้ครับ
ก็ได้โอ้ยอะไรกันเนี่ยแค่นี้นะ
อะไร
เนี่ยลมเสีย
อารมณ์เสียโวยวายเสียงวีนมาแต่เช้าเลยเธอ
จะไม่ให้ฉันวีนไม่ให้ฉันเหวี่ยงได้ยังไงจ๊ะจ้างช่างมาต่อเติมบ้านนี่เลยสัญญาส่งมอบมา2 เดือนแล้วยังไม่เสร็จเลยแล้วไงรู้ปะทำผิดแบบอีก
เอาก็ให้เขาแก้สิ
อ้าวแล้วพอบอกให้ลื้อไงลื้อไปทำตามแบบจะมาคิดตังค์ฉันเพิ่มบ้าหรือเปล่าคิดตังค์เพิ่มอะไรไม่ได้นี่นะถ้าไม่ใช่คนรู้จักแนะนำมานะฉันจะฟ้อง
เดี๋ยว
ขึ้นโรงขึ้นศาลให้เข็ดไปเลย
ไอ้ขึ้นโรงขึ้นศาลแล้วฟ้องเนี่ยได้ยินมาเยอะแล้วมันอาจจะสะใจแต่ถ้าทำไปจริงๆนะ เสียเวลาเสียเงินเสียทองเยอะมาก และบางทีคดีจบคนไม่จบนะ
แล้วให้ทำไงอ่ะ
ผ่านอะไรมาเยอะมากขอให้เชื่อ มีทางเลือกมีทางออกสนใจปะล่ะ
เฮ้ย สนใจ
ทางนั้น สถาบันอนุญาโตตุลาการหรือว่า THAC เนี่ยเขาเปิดให้บริการระงับข้อพิพาททางเลือกซึ่งง่ายๆเลยคือเขาก็จะเชิญคู่กรณีทั้งสองฝ่าย หรือคนที่มันทะเลาะกันสองฝ่ายเนี่ยนะ
สมมติฉันทะเลาะกับเพื่อน
มาเจอกันแล้วก็ตั้งบุคคลที่ 3 มาเป็นคนกลางในการประนอม หรือว่าจะทำหน้าที่เป็นอนุญาโตตุลาการเลยก็ได้ก็คือวินิจฉัยชี้ขาดไปเลยว่าเรื่องนั้นเนี่ยใครถูกใครผิดพอได้ข้อสรุปข้อยุติที่ชัดเจนก็ปฏิบัติตามข้อตกลงนั้นกันไปซึ่งวิธีนี้เป็นวิธีที่เขานิยมใช้กันทั่วโลกแบบเป็นสากลเลยทั้งคดีแพ่งแล้วก็คดีพาณิชย์เพราะอะไรรู้เปล่า
เพราะอะไร
เพราะว่ามันสะดวก 1 2 มันประหยัดเงินประหยัดเวลารวดเร็ว
มีอีก
มากกว่าเวลาที่เธอจะต้องไปขึ้นโรงขึ้นศาลซึ่งโอ้ยขั้นตอนมันเยอะมากเหนื่อยมาก
จริง ๆ แล้วก็ยังรักษาความสัมพันธ์ที่ดีไปด้วย
ถูกต้อง
แต่ประเด็นก็คือฉันจะไปหาบุคคลที่ 3มาจากไหน
นั่นแหละเป็นเรื่องที่ยากที่สุด แต่มีคำตอบให้
ครับทางสถาบันจะมีการขึ้นบัญชีบุคคลนะครับที่มีความเชี่ยวชาญ และมีประสบการณ์ในด้านการระงับข้อพิพาททั้งทางด้านอนุญาโตตุลาการ และการประนอมข้อพิพาทนะครับโดยในบางครั้งทางสถาบันจะมีการฝึกอบรมนะครับผู้เชี่ยวชาญหรือผู้ที่มีประสบการณ์นั้น เพื่อให้แน่ใจว่าผู้ที่มาทำหน้าที่เป็นอนุญาโตตุลาการ หรือการประนอมข้อพิพาทจะสามารถทำการระงับข้อพิพาทให้กับท่านได้เป็นอย่างดีครับ
สะดวกนะประหยัดด้วยสามารถยุติข้อพิพาทได้อย่างรวดเร็วดีอ่ะ
ไม่ว่าจะเป็นเรื่องเล็กระดับบุคคลปัญหาการค้าแบบ SME หรือว่าข้อพิพาทระหว่างประเทศก็สามารถให้สถาบันอนุญาโตตุลาการหรือว่า THAC ช่วยได้หมดเลยนะครับ
หรือจะโทรมาสอบถามก่อนก็ได้นะคะที่เบอร์ 02-018-1615 หรือ www.thac.or.th หรือ Facebook THAC จะมีเจ้าหน้าที่ยินดีให้คำปรึกษาเบื้องต้นแล้วก็ขอให้คำแนะนำฟรีตลอดเลยค่ะ
วันนี้เราสองคนลาไปก่อนนะครับ สวัสดีครับ
สวัสดีค่ะ
to the challenging times that we have. While Asia is still at the heart of business and the global center of trade continues to shift in Asia, no region in the world has been spared from the onslaught of the COVID-19 virus pandemic. The COVID-19 pandemic has caused a grave disruption to worldwide mercantile activities and has tested both financial systems and legal systems of all countries. It has led to massive job losses. We've had dislocation of supply lines, production lines being affected, and demand lines also affected. All countries have enacted travel restrictions preventing non-nationals from crossing their borders. Many countries have issued work-from-home orders and have directed that non-essential business should close down until further notice. Such preventive measures are aimed at mitigating and slowing down the spread of the virus, but however, they also have a disproportionate and disruptive impact on work. And indeed, our ADR and legal sectors have not been spared by this cruel pandemic. As the world around us continues to tackle the pandemic and business models continue to evolve, lawyers and all those involved in dispute resolution also need to rise up to the new challenges, as well as to seize new opportunities to try to improve their current situation. So in this regard, the theme of the THAC International ADR webinar series is indeed very apt. It calls upon all of us to look at how we should pave the way for effective use of ADR in commercial and investment disputes. In order to decide the future of ADR, one first needs to take stock of the recent changes and developments to ADR. Most of you will be rather wary of having to listen to talks on force majeure clauses, frustration of contracts, and how to hold virtual hearings. These discussions are now rather outdated, as we have all learned to adapt to use virtual hearings. We should instead focus our resources and brainstorm and try to deal with how to solve some of the recurring problems that exist in the course of holding virtual hearings. And we shall have the opportunity to do so today. And I hope that we can all share our experiences together in this regard. Let me say a few quick words about the THAC. The Thailand Arbitration Center, THAC, is an institution that provides alternative dispute resolution services, primarily focusing on arbitration and mediation services for cross-border disputes. THAC was founded in 2015 and commenced its operation in the same year. Its main aim is to promote and strengthen the ADR system and ADR services in Thailand. THAC has been seeking to promote ADR-friendly measures and regulations in Thailand. THAC has worked closely with the Thai government, including the Ministry of Justice, in making Thailand a more friendly environment for international arbitration. While work visas are still required for non-Thai nationals to work on arbitrations in Thailand, recent changes to the legislation assisted through coordination of THAC means that it is now possible to leave the administrative matters of dealing with work permits with the THAC. Arbitrators can now pick up their work permits at the THAC center on the day when they come in to sit in an arbitration. And THAC is continuing to work with the government and to try to improve the arbitration environment and to make it easier for foreigners to come to Thailand to participate in arbitrations. One of THAC's aims is to cater to end users of arbitration which has civil law as a choice of governing law. THAC also has friendly cooperation with other national arbitration centers, particularly those in the ASEAN and those regionally close to the ASEAN region. THAC also hopes to work with distinguished arbitration market leaders in arbitration, such as the ICC and HKIC, to promote arbitration in Thailand and also in the region, because it is better for all arbitration centers to try to work together and to encourage more businesses to use arbitration. So THAC's location is in the heart of Bangkok. It allows easy and convenient access, and there are full facilities offered, including state-of-the-art hearing and conference rooms, which support both virtual hearings and physical hearings. And the service fees of the arbitration and mediation offered for these rooms are reasonably low and cheaper than those offered in other ASEAN arbitration centers. So I urge that all of you should come and pay a visit to the THAC premises the next time you're in Bangkok. THAC has also been active in putting together large conferences and has worked together in putting together events with major multinational bodies, including the Arbitral, the World Mediation Organization, Global Mediation Forum, and the IPBA. So due to the current COVID-19 situation, it has not been possible for THAC to go ahead with the original in-person ADR week, but we are fortunate to have been able to convert all the in-person events into a series of online webinars. Now that I've completed my brief opening remarks, I would like to move into the first online webinar of the THAC International Arbitration Series 2020. So I would like to invite the speakers to all share the screen with me now, please. So it gives me pleasure to introduce our two speakers for the first webinar session of the ADR series. The topic of this first session is the future of ADR in 2020 and beyond, recent changes and developments. Our first speaker is Professor Philip Young. He really requires no introduction. In addition to being one of the most experienced arbitrators in Asia, he is also one of the mentors for all the generations of arbitrators in Asia after him, myself included. We have all heard a lot about how to conduct a virtual hearing, but there are some rather problematic issues which can involve dirty tricks played by unscrupulous counsel. Philip will deal with some of these more thorny issues, and we shall listen to him share his experiences about the coaching of witnesses during the virtual hearing process, and also some of the practical difficulties faced by counsel and arbitrator alike during cross-examination of witnesses. Our second speaker, Professor Abe Shinichiro, is a distinguished Japanese arbitration lawyer. He's a professor of arbitration in several renowned universities in Japan. Shin will share his views with us on the current ADR environment, and his main focus will be on mediation, and he will give us examples of how ADR, excluding arbitration, has been developing and how he envisages the future shape of ADR. He shall also deal with some of the practical difficulties in getting people together at different time zones. So we have all seen a deluge of virtual hearing protocols coming into being. There are four significant protocols in play. First, we have the ICC's guidance note on possible measures aimed at mitigating the effects of COVID-19 pandemic. And this provides a checklist for virtual hearing protocol to ensure that all parties are treated equally and given the opportunity to present its case. The second guideline is the CIR guidance note on remote dispute resolution proceedings. This gives guidance on technology and logistical and procedural issues relating to virtual hearings. Thirdly, we have the sole protocol of video conferencing in international arbitration, and the sole protocol provides best practices for a virtual hearing. And finally, we have the HKIAC guidelines for virtual hearings, and it provides practical guidelines on matters including the preparation of electronic bundles, transcription, and interpretation services. There are, of course, many other protocols around, but these four are the most pertinent to the Asia-Pacific region. So without much further ado, I would like to invite Professor Philip Young now to give his presentation. Philip, the virtual floor is now yours. You have to unmute your microphone. Can you unmute your microphone?
Yes, I'm doing that. Thank you very much, Colin, for your very kind words. And I'm very honored and privileged to be invited to give a talk at the opening speech. I must say that compared to a lot of good writings which I've come across in recent months with regard to virtual hearing, I only have a very limited experience. I've got only 3 virtual hearings so far. It's very limited really to share with everybody, and I really hope to learn more from Colin and Shane, and as well as all the other attendants or participants, their experience in order to enhance my future experience in dealing with COVID, in dealing with virtual hearing, which is going to, I'm afraid, going to last for a long time to come. Now, I think I can skip the first slide and go to the next slide, please. Now, when it comes to remote hearing of witnesses, I'm saying just 1 or 2 individual witnesses. It is not uncommon. I think most arbitrators have experience, and that is by by video link. In the slide, I mentioned the various grounds which you have to get leave in order to actually in order to have witness to attend by video link, especially the key witness. I refer to the first line to Polanski's case because I come across several of them because the Polish director was afraid to give hearing in person in England because of the danger of being arrested and extradited to the States. Now, those are some very valid grounds, but there can be other grounds as well. And I come across less than a year ago when Hong Kong was still having a lot of unrest and rioting, which is known to the world. I was a sole arbitrator, and a key witness from Philippines refused to come and asked to have video link evidence. And this was objected by the other party, and I don't like it as well. Eventually, he was forced to come to Hong Kong and attend the hearing and give evidence very satisfactorily. And actually, he moved around to do quite a bit of shopping, as I understand. So nothing turns out, but I'm just trying to show that people are generally resisting in video link unless for very good reason. Now, the reason is actually given by Bernard Eder, Mr. Justice Bernard Eder, as he then was, in a 1914 case. It was a case having to do with dishonesty, and it was a 4-day hearing with interpreter because the key witness can only speak Russian. And Sir Bernard Eder expressed his disapproval, if I use the word. He wasn't happy at all with the evidence given. So that was really the old days. And there are other technical problems which many of us could have come across, like disconnection and interruption and so forth. Now, if we can go to the next slide. Next slide, please. And now comes the coronavirus, the pandemic. Things has changed quite completely. Now I just put the 2008 financial tsunami there, just to say that now that after more than 10 years, we have another disaster. But I thought all of us, if I may congratulate you all, we are very lucky. Amongst all the misfortunes throughout the world, we are in a business that we will see a lot of business coming. Whether you are arbitrator, whether you are lawyer, whether you are arbitration-related persons or service provider of any kind. Now, primarily, if you go back to look at the financial tsunami, it provides a boom to litigation afterwards. At that time, I was involved in some 30 or 40 cases amongst the 2,000 cases of shipbuilding contract going to London. Every case involved multi-million US dollar. And it certainly make a lot of arbitrator, many of the lawyers, and arbitration-related services providers make them very happy. A lot of experience has been accumulated. A lot of money has been made, certainly. So I'd like to congratulate you all, notwithstanding we are still in the midst of coronavirus, and we don't see the end to this misfortune yet, to the whole world. Now, virtual hearing, let's look at the position in mainland China. It has the PRC Supreme Court has given a notice on 14th of February of this year. It is only in Chinese because I can't find the English version. Essentially, it says unless both parties in the civil litigation agree to virtual hearing, the court should not hold a virtual hearing. Now, that, of course, influences the other well-known Asian arbitral institutions like CTAC or Beijing Arbitration Commission. Now, I'm involved in one or two of them, and sometimes it's frustrating because you cannot even fix a hearing day because you don't know how long it will last. So after a few adjournments, you just put it on hold. And the case is going to sit there, I don't know, for another year to come or whatever. So that is the attitude until, of course, the Supreme Court has changed in mainland China. Otherwise, that is the position in mainland China, which is, of course, very close to Hong Kong. Now, if we look at the international arbitration, especially if we look at the English court, before March 2020, now it's usually adjournment, and I think many of you will have that experience. Adjourn. Hopefully, it will be all over in a few months. Very much like SARS. But after March of this year, English court has actually changed to its default position, which is on the slide. Now it's actually to the family and to the commercial court. I think it was a notice by the law, by the chief. I forgot who. Anyway, it says now in all jurisdiction must be that the hearing should be conducted with one or more than one of all participants attending remotely. And there are more reported cases both in England, in Hong Kong, and I'm sure other places as well, Singapore and other Malaysia. I don't know, but I'm not actually going through all those cases anyway, in which the court refused adjournment, unlike the attitude before March, whether it's a direction hearing or whether it's the evidential hearing. Now, it certainly has a lot of influence on arbitration. If that is the position taken by the court, at least if the arbitrators stand firm and refuse adjournment, it is hard to attack the arbitrator in breach of natural justice or due process. So as far as I myself is concerned, I noticed most of my arbitration refused and adjournment now, and it's going to turn to virtual hearing as there is no other way to do it. Can I have the next slide? The conference technology has actually come a long way. Even within these several months, as I said, I have 3 virtual hearings, one in CTEC Hong Kong, the other one in HKIC, and the other one, the last one was from my office. They all went very smoothly. Of course, I'm talking about the arbitrator. I'm sure the parties and their counsel will have a lot of arrangement, and certainly the service provider and the virtual hearing provider, the service provider, and the transcript and so forth. Now, I think we all have heard praises from counsel and arbitrator or arbitral institution saying the virtual hearing is now going on rather smoothly. And even if the old normal returns, that means people can travel around and so forth, we are not going to attend in-person hearing in order to save the huge expenses of traveling, hotel, and the time spent on traveling. I'm not so sure, but perhaps perhaps something that goes halfway is very likely. That means half of it would go virtual hearing, and perhaps half or even less will still be in person. I'm not so sure. It's all prediction. Nobody knows. And of course, the technology, conference technology, doesn't stop here. It's still improving. So it's hard to say what is going to be the future. Now, there are still people saying that technology is not infallible, and there has to be a plan B and so forth. As far as my cases are concerned, it went very smooth. Certainly, it wouldn't need a plan B. Can I have the next slide, please? Now, there are a lot of problems still with virtual hearing, as I understand, and Colin Nant, our moderator or our chairman, will later guide us to those areas, or even more areas if you can think of, if the participant can raise it, then we can deal with it in the discussion. As I've mentioned, I like to learn something from you all in order to improve my experience and my knowledge of virtual hearing. Can I have the next slide again? The next slide. Yes. Now, amongst all those problems, I just touch a little bit. If you would like to, if you like it, just to warm up the discussion later on. Now, firstly, is a matter of coaching of witnesses, the fear of coaching of witnesses. Now, I just say in one of my cases, a witness was testifying at home. The opposite party will have to instruct local law firm to send a lawyer to supervise side by side. Arrangement will have to be made, and of course nowadays people cannot travel, so you have to engage local lawyer. I suppose there would need it would have to do quite a bit more work in order to brief the lawyer and so forth. I don't know how actual arrangement is lined up, but both parties were happy about it. Now, another witness had to testify at the CTEC sub-branch office in mainland China to ensure supervision and assistance, because the witness would need assistance as well. Some of the witness would not have knowledge to hearing bundle, although they get one, but they don't know how to find the document or so forth. So they need assistance as well as supervision. The one that the experience that I have that the witness had to testify at the CTEC sub-branch office went quite well, and I understand very cost effectively because the assistance was there, the supervision was there. At least neither party was unhappy about it. Now, the witness would, in all the witnesses that I went through, they all have to sign an undertaking, which I gave the wording. Of course, it can always be improved. As to its value, it all depends how you look at it. But certainly, you ask for an undertaking is better than not to ask for one. Now, that gave rise to one idea, which I want to, again, I try to trigger the interest of discussion later on. There are so many arbitral institutions throughout the world. Now, unless you have a total lockdown at home, nowadays, more and more places, I don't think you have a total lockdown. Very few countries or places, cities will have a total lockdown at home, which means that the witness cannot travel intercity. Otherwise, can a practice be developed with all the witnesses having to travel to a local, the same city, for example, Singapore, Kuala Lumpur, or Bangkok, to the nearest, the local, or at least the nearest, or even the nearest within the country, the arbitral institution. And the arbitral institution would line up to provide that service internationally. And the witness can testify under supervision and assistance of that particular arbitral institution. That will certainly give confidence to both parties and certainly to the arbitrator. Now, can I go to another slide? I'm coming to the end now because I want to have more time in the discussion that will follow. Now, the other example, which, or my very humble experience that I can give is that cross-examination. As an arbitrator, really, I don't conduct cross-examination by myself. But I've heard complaint. I've actually come across counsel saying that virtual hearing obstruct effective cross-examination. Now, in my 3 cases, I would say, or even other cases that I handled, or at least most of them, they are straightforward commercial disputes, breach of contract, and so forth. I believe it matters less, primarily because in those areas, commercial dispute, international commercial dispute, you have plentiful of documentary evidence, contemporaneous documents. So they usually only need the witness to tie up the story, tie up the background to the documents, and so forth, which will give the arbitrator a much better and clearer picture. And in those cases, demeanor of the witnesses doesn't mean a lot. Indeed, we have been telling all the time that we ought to disregard the demeanor of the witnesses, especially witness which is of a different culture or different country. And the focus should be the analysis of the evidence, which I follow, which I did. Now, but I can understand there are still cases, and I'm afraid more and more these days, which involve heavily in the dishonesty or fraud allegation, which concerns the allegations of dishonesty and fraud, real fraud and real dishonesty. Now, especially in those cases where you don't have sufficient documentary evidence, then it is difficult for the counsel, perhaps even difficult for the arbitrator to observe closely the body language of the witness in close examination, which is important sometimes, especially counsel come up with follow-up questions and trying to put pressure on the witnesses and so forth. Now, virtual hearing, like the webinar we have here, you can only see the face, but body language is very important. I've even heard people say that the whole body is important, even though which include the movement of your feet. The feet of the witness is important. So again, technology may overcome this type of problem. I've already heard that there is development or plans of having 3D dimension graphic picture, which would make it very much like real life in-person hearing. Those new technology, which I don't know, but I really look forward with a lot of interest. Now, I've come to the end of my time, and I look forward to come back to all of you when it comes to the discussion. Thank you for your kind attention.
Thank you, Philip, for sharing your valuable experiences and for those very insightful points. We shall discuss those issues with you immediately after Shin finishes his presentation. I shall now invite Professor Abe and Shin Ichiro to take the virtual floor. Shin, the platform is now yours. Please unmute your microphone. Thank you.
Thank you, Colin, for the kind introduction. I'm grateful for this opportunity to speak with you all. I will begin by taking a look at what ADR is now in our current day and some developments we are seeing, particularly in the area of mediation. Slide, please. Thank you. Next slide, please. Page 2. Yes. As you know, the aim of ADR is to tackle legal dispute without going to court. The most common types of ADR are conciliation, mediation, and arbitration. Arbitration lessens the burden on the court. For disputes that cannot be easily resolved by litigation, ADR offers a resolution that is voluntary, private, and confidential, fine-tuned by drawing on the expertise of specialists, simple and speedy, and flexible in responding to the circumstances. An advantage of ADR is that it offers a process that can be calibrated for the specific circumstances of each case. This flexibility comes from the ability of the parties to agree upon the dispute resolution process, as well as the content of the resolution itself. The process is constructed upon the specific needs of each party. The resolution is not dictated by law, and instead can be created based on the social rules in place between the parties. Next slide, please. Types of ADR. We can categorize ADR into 4 broad types. The first one on this slide is court-supervised mediation, which is very popular in Japan. As you can see from the slide, in 2018, there are over 5 million new lawsuits filed in the Japanese court. On the other hand, over 2 million filings were made to the Japanese court for court-supervised mediation. This means that approximately 30% of the filing made to the Japanese court were for court-supervised mediation. Next slide. The second category is administrative ADR, which involves disputes relating to statutory requirements. In this type of ADR, the administrative agency with the relevant expertise provides ADR for employees and consumers for specialized dispute in areas such as employment and labor law or construction law. The third category is private ADR. There are many subcategories within this category, such as ADR provided by various industry organizations, such as ADR provided by the Product Liability Center for product liability matters, or ADR provided by attorneys. Next slide. The fourth category is ADR through accredited institutions. This is actually a subcategory of private ADR, which has an advantage of a government-accredited ADR institution. Such institutions have the capability to handle a variety of cases in various areas of specialization. Again, using Japan as an example, ADR institutions specialized in the dispute of financial institutions handle approximately 1,200 disputes per year in Japan. Financial institutions are required to compile with an application for proceeding by customers, cooperate with documentary requests, as well as accept the special mediation recommendation made by the ADR institution. One very unique type of accredited ADR institution in Japan includes the institution which specializes in ADR concerning nuclear compensation claims. This institution has handled compensation claims relating to the 2011 Fukushima nuclear facility disaster. In past years, this institution handled up to 4,000 cases a year in aggregate. Recently, however, caseload number have begun to decline. Next, please. Now, let's look at some recent issues in ADR. I have listed what I believe to be some of the hot topics of the day here. In order that I don't go beyond the time allotted for my session, I will focus here on two of these topics and leave the reminders for discussion after this presentation. The first topic I'd like to discuss is communication between ADR institutions. For the development of ADR going forward, it will be important for world-class arbitration institutions to share their knowledge and expertise and participate in exchanges to promote interaction and communication between arbitration professionals across the world. On the path to raising the public confidence in ADR, I also look forward to seeing arbitration institutions supporting each other, even logistically. For example, by lending rooms for conducting arbitration and providing IT support to facilitate well-working virtual hearing. The second topic I would like to discuss is enforceability. I believe there are two approaches which are the most prevalent. One is illustrated by the approach taken under the Singapore Convention, and the other is the French approach, where the ADR decision can be confirmed by the court. Incidentally, neither of these methods is used in Japan. Next, please. Next slide, please. Regarding the Singapore Mediation Convention, as you know, the Singapore Convention will become effective very soon on September 12 this year. A key feature of the convention is that mediation settlement will be directly enforced by the countries that have signed the convention. It will not be necessary to go through a recognition and enforcement process separately in each country. And this is speedy enforcement, which requires the authorities in each country to act expeditiously. Next, please. One issue that comes to mind here is whether recognition of a mediation settlement is always appropriate or not. What if it involves illegality? Also, at this early stage, we cannot predict that the court will exercise its judicial power to determine the validity of a settlement. Next, please. Now, I would like to talk about the future ADR with a focus on arbitration. Going forward, I think it will be increasingly important to consider the interaction between ADR and the court. I identify two broad categories of situations in which ADR and litigation can intersect. I further analyze these in subcategories as shown on the slide. The first situation is, The first situation is when ADR, one more slide back. One more slide back. Yes, thank you. The first situation is when ADR moves to litigation. In the first subset of this situation, I refer to cases where the matter only moves in part to litigation. The key feature of ADR that creates this situation is that information cannot be compelled in ADR. In contrast, this is possible in the fact-finding process of litigation in court. In court-supervised ADR, Japan has a system under which the court may undertake the fact-finding functions and investigate evidence. Under the unsettled model law, there is a system under which the arbitration tribunal may seek the cooperation of the courts for investigating evidence. In the next subset of this category, there is a situation in which the matter moves entirely from ADR to litigation. This is where the case moves to litigation after the fact-finding has already been completed within the ADR process. Since the litigation proceedings based on the facts determined by the specialist arbitrators in the ADR process, this situation may be appropriate for cases such as medical malpractice cases. Next slide, please. The second broad category on my slide is the situation where litigation moves to arbitration. This is where the court moves the proceedings to certain approved ADR institutions. For example, in France, under the civil procedure law, the court is permitted to move matter to mediation before the court proceeding has commenced or after the court proceeding has already commenced. I understand that the law has various provisions for promoting ADR, in addition to the power to move court cases to ADR, suspending the legal proceedings, and even sanctioning parties who do not cooperate with the process. As another example, in the US, the ADR Act of 1998 has provisions which encourage the district courts to develop ADR programs and use the ADR process. Next page, please. Many of you will be familiar with the mechanism listed on this slide, MED-UP, ARB-MED, ARB-MED-UP, so I skip. Next slide, please. In closing, please allow me to share some thoughts about ADR in the current times. Under the pandemic, there is a possibility that courts worldwide may shut down or suspend services, except in England and Hong Kong court, Philip just mentioned. COVID-19 has seriously disrupted the functioning of the courts, particularly with respect to the court hearings and decision-making. However, this situation, go back to next, before, one slide back. Sorry, go back. However, this situation represents an unprecedented opportunity to highlight the effective use of virtual ADR, especially virtual hearing for arbitrations to resolve disputes. Virtual ADR has continued during the pandemic and has proven to be much faster than the court. I heard that the HKIAC has concluded 28 virtual hearings up to today during the pandemic. It is a fantastic accomplishment. This experience has proven that this form of ADR has continued to function effectively during the pandemic, where other organizations and businesses were disrupted. So swift resolution of dispute is important more than ever, and the use of virtual ADR is essential for this. The time has come for the expanded use of virtual ADR and virtual hearing. Thank you. Next is my last slide, please. Yeah, thank you.
Can you see me? Yes. Thank you very much, Shin, for giving us an excellent presentation and sharing your perceptive ideas with us. So there are a couple of questions coming up on the Q&A session, which we've reserved more time for the Q&A, and I encourage all of the attendees, if you have questions to ask, now's a very good time. We've got two very experienced and eminent experts who can help you. When was the last time you had legal advice for free? Now, before we do that, I have a few questions to ask both of you, Philip and Shin. Firstly, could I ask Kun Benyapa, could you put up page 5 of Philip's presentation, please? Thank you. Now, one contentious area that is arising quite frequently these days in the context of suggestions for virtual hearings is a situation where one party makes an application to have the hearing heard virtually. The tribunal agrees, but one party opposes holding a virtual hearing. And there are more situations coming up, and obviously the tribunal needs to make decisions on whether to go ahead with virtual hearing or not. Quite often it would depend on the choice of the arbitration rule. So different rules allow for different rights of whether you have virtual hearings or not. But it also depends on the factual circumstances. My question is for Philip. So, Philip, may I first ask you your experience and how you deal with the situation where one party just refuses to hold a virtual hearing? Philip?
Thank you, Colin. Yes, it's a very interesting question, and I suspect a lot of arbitrators like yourself and many others in the participant will have experienced this. In my case, yes, very rarely you have two parties both would say, well, we want virtual hearing to the arbitrator because we don't, including the lawyers, we only come a few months into this situation with virtual hearing, and many of them would not have experience and without experience, you don't have full confidence about how it's being done and so forth. Now, the few examples I've gone through is you always have a case that one party would be reluctant to move forward, and the other party, usually represented by very experienced law firm, wish to push ahead. Now, in my case, I feel that firstly we all concerned and we try to use a German. Sometimes by agreement of both parties, and even the arbitrator wants a German, want to encourage. But come March, when the courts start to embrace virtual hearing, now, firstly, we are comfortable. We are no longer afraid of being accused of in breach of natural justice or things of that sort. As you know, many arbitrators are paranoid about challenges like the breach of natural justice. So we are a lot more. I myself is a lot more confident to push ahead with virtual hearing, but the devil is with the detail. Every time you have to listen to the opposing party as to why the party is against virtual hearing. There could be legitimate reason. In that case, the arbitrator will have to try to make sure that the difficulty is overcome. It links to your point 3, which is a perceived inequality of arms, for example. Another thing I would do is usually try to encourage them to contact the institution. In my case, HKIC, for example, encourage them to approach the HKIC for guidance, because the HKIC and many other institutions, which you have read out the guidelines earlier during Colin, during your opening, they have vast experience and they go into a lot more greater detail, a lot more than I myself is aware. So they will be able to help the lawyer, the party of one side, to overcome those difficulties. Now, it's just like making any other orders. Try to help the difficult party to overcome the problem that they have. At the same time, try to see whether it is out of a motive, out of an ulterior motive of trying to delay the matter, which I call the recalcitrant party. Now, but if I'm certain that it is trying to be difficult and recalcitrant, in that case, I'll push forward, because I'm no longer afraid if I can fully justify my direction or order of going ahead with the virtual hearing. So I think that is the attitude I'm taking towards virtual hearing now.
Yeah, thank you, Philip, for those points. And I think usually the key point that we need to look at is the question of whether parties are treated equally and fairly. So as long as parties are treated equally, then one does need to look at the factual matrix before pushing ahead with virtual hearings. Next question, time and time again, for those of us who act as lead counsel or arbitrator, we find ourselves getting quite tired because we find ourselves sitting sometimes late in the evenings until the wee hours of the morning. This happens when parties come across from different corners of the world. So let me give you an example. So, for example, if you have the seat of arbitration in Hong Kong, and one arbitrator comes from, say, Hong Kong, one comes from Australia, and one comes from London. One of the parties and their counsel are based in Dubai, and the other lot are based in Japan. Let's say they're being led by Shin. So in that sort of situation, there's always a lot of tussle over what is the ideal time and in which the hearing time should be fixed. And I've had a lot of thought about this matter. And at the end of the day, I think a lot of time can be saved if one could come up with some kind of protocol where you can basically predict or be guided as to how you should deal with issue of time differences. So there will always be arguments of unfairness, of having to fight a case at 2 a.m. or sit as an arbitrator at 2 a.m. Your time, when the time on the other side is bright daylight. So I think it would be fairer to try to peg the time zone to the seat of arbitration in the event that parties cannot agree. But it does not necessarily mean, and it should not mean, that sitting times should start at 9 a.m. or 10 a.m. Sitting times can start at 2 p.m. and end at 8 p.m., for example, because at the end of the day, we are all quite reliant on operators, technocrats, basically, who will help us with virtual platforms. I will deal with a question on this later on about which virtual platform is more ideal for arbitration. But putting the question now to Shin. So Shin, how would you respond to my example and proposal of having time frame being pegged to the seat of arbitration, but starting later in the day to try to accommodate others from other parts of the world? Shin?
Yeah, thank you, Colin, for this question. I think the prerequisite of the Colin's question is the time zone should be the same place as the seat of arbitration. Having said this, this may be perceived as less advantageous to one of the parties in certain cases, which Colin gives us the example. But problem may be that if the virtual hearing may start at 1 a.m. Tokyo time, arbitrary tribunal should be very careful about this time zone problem, which can trigger the lawsuit of setting aside of arbitration because of unfairness, health condition, not treated equally, etc. I think for this purpose, we need to have several breaks, at least 60 minutes or even 45 minutes, if time zone of the countries where witness or other participants would live in midnight. And probably recording may be something helpful for the arbitration or even mediation, but we cannot ask questions or cross-examination. That's a problem. Thank you. This is my preliminary answer.
Thank you. It would be interesting to get some views from the audience on that, because at the end of the day, one agrees on the seat of arbitration, and if one cannot get to the country, one may have to go to another country within the same time zone. But obviously, this is an interesting area which we need to look at. Let me quickly run through some of the questions first that have come up. William Lai QC has asked what kind of online platforms are being used, and is it Zoom or Microsoft Teams, Cisco WebEx or Skype Business, and what is the most efficient or effective platform? Perhaps I can give my views first, and then the speakers can contribute to this. So all of the systems mentioned, to me, they're useful, but they are secondary systems. They're not primary platforms, virtual platforms. Primary virtual platforms would be platforms like, well, I enjoy using Epic Global, or some people like Opus 2. And so basically what it is that you have got two different machines, two different laptops running two different screens, where on one side you've got a Zoom to look at witnesses and present your submissions to tribunals. And on the other side, you have got the simultaneous live transcript coming online together with the live translation, language translation services. And at the end of the day, you need both. You cannot just have Zoom or WebEx or Cisco WebEx Skype, Microsoft Teams running by itself, because at the end of the day, you need to have your live note, and you need to have your live transcription. You need to have your breakout rooms for counsel, because if I was when I'm acting as lead counsel, my solicitors may be thousands of miles away, and I need to talk to them in a safe environment. You can't just rely on using WhatsApps or another exterior system. Sometimes you need to go into your breakout room. And it's the same when you're the arbitrator. When I'm the arbitrator, I like to talk to my co-arbitrators on the platform itself. And I think it's important that both systems run in tandem, side by side. Perhaps, Philip, you might be able to share your views. You need to unmute your microphone, Philip.
Sorry. Colin, thank you very much. That's what I say. I attend this webinar to try to pick up something, and I pick up idea from you, Colin, a while ago. I just say I have nothing useful to add. I'm not a technical person. I just try to catch up with all the technologies that is coming coming to me. So I would rather skip that.
Thank you. There was an earlier question that was interesting, and it basically said that because cultural backgrounds of witnesses are quite different from different countries, one should not rely so much on cross-examination. I think something along the lines that it's important not to just look at the demeanor of witnesses, because demeanor is tied to culture. The question that was asked was whether side by side nod of the head means a no or a yes in different cultures. I think what is important is that one doesn't just look at demeanors. You have to look at it in the context of the questions that are being asked. Probably a useful article, a useful book chapter to look at is one that was written by Michael Huang and myself, and we wrote the second edition that came out last year. It's called Taking the Witness and Cross-Examination and Cultural Differences. What actually is important is that when you are lead counsel and you are running a certain case, a certain line of attack, you are not trying to just discredit the witness on his demeanor, but you're trying to get visual cues as to how you're doing in the cross-examination. And sometimes when that's happening and you see witnesses with clenched fists, and they're getting quite stressed, or sometimes you have witnesses who start drumming their feet up and down, basically. So counsel will notice this, and they will go in deeper to rephrase their questions to go in for the kill. But a tribunal would also be looking at this, and they're not just looking at demeanor, because documents are being put to the witnesses, and at the end of the day, it's the answers that are given by the witnesses. So the demeanor in itself does not actually mean that much, but it gives a signal as to how the attack is coming. But at the end of the day, it's up to the skill of counsel to put the witness in the corner, and if the witness cannot explain his way out, obviously the next question could be, well, did you write this witness statement yourself? And sometimes these visual cues are important to the tribunal, because the tribunal is trying to search for the truth, and cross-examination is the greatest engine to search for the truth. but that is an important point. You don't just look at the demeanor of the witnesses, but you look at the end result. And the visual cues only get you so far, but you still have to convert that goal. Philip, can you share your experiences as an arbitrator when you're looking at demeanor of witnesses?
Yes, I think it really goes into cultural bias, and people can have an imputed bias by looking into these things. But there are numerous cases saying that you should look at demeanor, even people of your own kind. People share the same culture. And I think that is unarguable. So many judgments and leading authorities have said it. But of course, in real life, especially when you have a in-person hearing, it's very hard to get away. As Colin, you have mentioned, it's very hard to get away with demeanor. But I'm not so sure. But you have to know the limitation. Sometimes, for example, if you ask a witness a simple question, they couldn't answer, and they hesitate and try to evade. And then a rather difficult question, it looks like he has been taught in how to answer. He will come out fluently. Now, this sort of things will give rise to suspicion. And I think any arbitrator is very hard to get away. When it comes to different culture and different people, I remember even Scranton. Scranton 15 years ago had already been saying something like that, saying that foreign witness giving through interpretation is wholly unreliable to look at the demeanor. So I mean, it's not new. I think more recently, I remember in 2018, Legge, Mr. Justice Legge also talk of similar things, that especially be careful with demeanor of people from a different country or different culture. So I think we all have to recognize it. You look at demeanor in a more generic manner, like what I've explained, what I've said. I'm not sure I'm right, of course, but I do have influence or impressed by a witness not being able to answer a simple question or think a long time to come up with a simple answer with a very simple question, but come up with fluently with complicated question. I mean, it's just one of the manner which you come across which will give you suspicion. Now that doesn't go into any particular culture, and I'm not sure I'm right also. The more important thing, as far as I'm concerned, is of course the documents, which are always plentiful in my cases in international commercial arbitration. You look at the documents diligently and try to analyze them. I think is a safer way.
Thank you, Philip. The next question comes from my friend Robert Rhodes QC. So Robert says, to overcome the problem of possible witness coaching, might it be helpful to have a 360-degree camera in the room where the witness is giving evidence, and for him to be seated at the table which has no papers on it apart from the agreed document bundle? Before I pose that question to both of you, I would say yes. I mean that would be the ideal situation to get around coaching. But the difficulty is this issue works if the witness is seated at an arbitration center somewhere. So if he goes off to Fleet Street Arbitration Center or Maxwell Chambers in Singapore, well, that's fine because you have all the technology there with revolving cameras. But what happens if the witness is giving evidence from his home, from a cluttered bedroom, and he's got a laptop there and sitting there, you would not, in that situation, likely have anyone being in his bedroom monitoring him and looking to see if there's a little there's somebody hiding there who's holding up answers to questions in cross-examination from opposing counsel or from the tribunal. So that is the difficulty. And earlier on, the three of us on this panel had proposed that perhaps we should have a protocol where in situations where it is one party insists on cross-examining the other party witnesses, which would be de rigueur in all heavily contested commercial arbitrations, you should have the arbitration conducted at an arbitration venue. So, like the HIC in Hong Kong or Maxwell Chambers in Singapore, because at that venue, you then have somebody around who can help to make sure that there's no lawyer around or party around coaching the witness. And you would also have a 360 rotating camera in such position. But perhaps I'll invite both of you, Shin and Philip, to address the Robert Rhodes QC question on this.
Yes, I also agree with Colin's view. And the regional arbitration institutions and also mediation institutions we can use should coordinate this issue and make rooms available for this purpose. This is a real coordination worldwide and also help arbitration more fair or look fair. Thank you.
Colin, I think Robert Wright's question or comment, and I thought it actually just tie in with the idea that all the institutions, arbitral institutions worldwide, will have to tie up to provide that kind of service and upgrade their facilities. Exactly as Colin, you have mentioned in your answer, that is something which would solve this problem. Sometimes it's not just the 360-degree camera, which is important. There are other small things. Somebody need to assist, somebody need to supervise. I have one virtual hearing which the arbitrator suspect the witness keep looking at the mobile. Now, you can see it, but you never know what he is watching at the mobile phone. And since the counsel did not stop, it's very hard for us to make any comment by asking what you are looking at, what is in the mobile phone. Now, these are the sort of thing which can be resolved if testifying in an arbitration center under the supervision of a third person on top of 360-degree camera.
Thank you. So I think that also addresses my friend Ricardo Onkiko's question, where he says to see the demeanor of witness. Perhaps the tribunal can require to see the witness's whole body on screen, seated and with nothing in front of him. But obviously he needs to have the screen and the questions being put to him, so he needs to have the documents in front of him. The difficulty is you cannot monitor the person if he's in his or her own home. So perhaps he might just show himself or herself without anyone in the room, and then when the cross-examination starts, someone comes into the room. So I think that ties up also with Philip's last point about it's still very important to make use of arbitration center venues because they can provide this sort of facilities and also act as a neutral checker to make sure there's no poaching going on. There are other interesting questions that are coming up, and I think two are quite similar. One deals with how do you deal with confidentiality issues, and how do you make sure that for the case of the EU, there's data compliance with the GDPR, and whether there's any technical tool available so far to ensure protection of confidentiality. So this is a more difficult question because at the end of the day, confidentiality and arbitration can only be as confidential if the players agree to be confidential. So if somebody leaks out the code of the document, or the hackers coming in, I mean, that can happen in any event. But perhaps Philip, I don't know if you had any experiences on this. Basically, the HIIC protocol does deal with the issue of confidentiality protection, and I wonder if you have sat in any cases which apply the HIIC guidelines for virtual hearings, and also the ICC guidelines for measures on mitigating the effects of the COVID. Perhaps Shin and Philip can share your experiences.
Collins, I don't have any particular experience or concern about confidentiality. I've, of course, heard a lot about people discussing it, and even those platforms had tried to improve the security and confidentiality of it. But I personally have no first-hand information. Thank you.
Abe,
Yes, this is a very difficult question, I guess. And confidentiality and data protection is very important. And this is probably 70 or 80% is for the IT issues. And from my experience, people are always concerned. Japanese people are always concerned about data protection or leak of data. For example, if we do mediation in the virtual situation, and this mediation would be recorded, and this would be the becomes the proof after mediation does not work, go to court, and it becomes a proof. What happens to other parties, opposite parties? This is very important. We have to develop something good idea and. In the future, now and in the future. So I'm now always thinking about this issue, and not a very best clue yet. Thank you.
Thank you. There's an interesting question from Zaina Al-Halabi, where she wants to know how would ADR address the issue of technological differences that may exist between two parties coming from two different nation states. So perhaps you have one set of counsel coming from, let's say, Korea or Japan, where the internet speed and technology is very advanced and fast, and perhaps a tribunal seated in London where the internet speed and technology is also very efficient. But perhaps in a third world country, counsel is struggling with internet, is struggling even with basic facilities beyond a laptop, for example. So I think the question is, how do you deal with that? And I I think the follow-on concern that she would have is that could later on the party who came from the less developed nation state and did not have enough facilities, could that party apply to challenge the award because it was not given full opportunity or equal opportunity to deal with the hearing? So this was my, if I can ask Kun Benyapa to put up page 5 of Philip's presentation, please. Well, while that's coming up, perhaps Shin, you may want to give your views on this. So, what would you think, and Philip as well? What would both of you say to that sort of challenge coming up later on? Because there is a perceived inequality of arms. So perhaps you can deal with this while Kun Benyapa is putting up page 5 of Philip's presentation.
Okay. I think I'm a university professor and also using Zoom right now to lecture to the students right now because coronavirus is still increasing in Japan. And sometimes students video is not working well, was not working well. So at that moment, I have to continue or I have to repeat again. But for arbitration or mediation, it is very critical for other parties to say something and then shut down. And the opposite person think about something different after for a long time, then going up and not true thing maybe appear if the coaching would be happening. So I think at this moment, at least arbitration institutions or mediation institutions in each jurisdiction may be well equipped internet. So if this happens, we'd better advise the other party to go to the at least arbitration institutions in this jurisdiction, in their jurisdiction, and do this kind of oral hearing or something which should be continue, not suspend, and asked and appealed by the opposite side. This is unequal or unfair. That's it. Yeah, thank you.
Thank you. Philip?
Thank you, Colin, and thanks for the question. It is very interesting, but if I may say so, when it comes to inequality of arms, arbitration has always been bad. If you look at the courts, Hong Kong court, English courts, and the CPR, one of the aim is to ensure equality of arms. But when it comes to arbitration, actually inequality is very much the norm. Fortunately, most commercial cases, both parties are sophisticated enough usually and rich enough. Otherwise, but still I see a lot of cases where overpower by when it comes to counsel or expert and so forth, and one party try to overpower, overarmed than the other party, and usually, as far as I'm concerned, the arbitrator will do nothing to ensure equality, unlike the court, for example. So I think when it comes to virtual hearing, it would still very much be the same. It would still very much be the same. But of course, if one party say I can't have access to virtual hearing, that is a different matter. You have to ensure the natural justice. You must ensure that the parties will have equal opportunity to present their case. But if it is just a complaint of inequality, it is very difficult for arbitrator to do something. Party from the developing country can still instruct firms which are having very good technology, conferencing technology, and can overcome by instruction of a lawyer who will be able to assist the party. For example, of course, there could be problem with witness and so forth, but I'm sure the parties themselves can overcome. So it's going to be rarely come to an arbitrator unless it would because the arbitrator cannot do anything too much to make sure there is actually equality of arms. But you can always try to thought of some way to make sure that both parties would have a reasonable opportunity, and reasonable depends on the circumstances of the case, to present the case. And I think that is the maximum arbitrator can do.
Thank you, Philip. I would tend to agree with what you have said, because at the end of the day, there's not much a tribunal can do. It is up to the parties to help themselves, because otherwise it would never end. I mean, for example, even if it was an in-person hearing, let's assume that one side has a lot of financing, and it goes and gets itself a top lawyer. Let's say it gets William Lai QC or Robert Rhodes QC, and the other side cannot afford the same type of standing lawyer of such standing, and goes off to get, let's say, a lecturer at a university. The other side cannot say, look, there's no equality of arms. I was outgunned because the other side had the better lawyer. And I think for virtual hearings, the point that could be made is as follows. If you were in the same country anyway, then you should go off to your local arbitration center and have your presentation done in your country. But if you had to travel to another country, I think at the end of the day, the travel fees of witnesses and lawyers would be much higher than the costs of computer equipment, webcams, and things like that. So I don't think it would be a strong argument to make to challenge an award. But let's move on. Interesting question for Shin. Mediation being a voluntary process, this is a question from Caleb. So how do you get a reluctant party to attend a virtual session in the wake of the COVID-19 pandemic? Next question I can answer, does THAC have training programs in arbitration and mediation? Yes, most definitely. Just contact the THAC and they'll put you in a program. But perhaps Shin could deal with the question about how to get the reluctant party to attend a virtual session in the wake of a COVID-19 pandemic. I suppose mediation is voluntary anyway. You can't compel anyone. But what are your views, Shin?
Yes, this is an interesting question. Yes, indeed. I think, as you know, this is very difficult to ask the reluctant party to go to the mediation. And so reluctant party may be conceived, but they are convinced to do something unless they have to go to court. So instead of going to court, mediation may much variety of areas which they can argue. I think this is a good advantage, meaning, for example, if the sports arbitration, I would say arbitration, or sports mediation, probably the court decision may be a damage claim under the civil law practice or something very limited resolution. But if the parties goes to mediation, there are a variety of conclusion how to deal with this, or one side is a sports player and the other is an institution, a sports institution. So at that time, there are various kinds of arrangement, like you can go to Olympic. Unfortunately, we don't have Olympic today because today is Olympic Day for Tokyo, but extended. So I think this kind of arrangement can be done by our, ADR mediation instead of go to court. This is one of the advantage to ask the reluctant party to involve in our mediation system. What do you think? Thank you.
Philip, what do you think?
Colin, I have nothing useful to add on this matter. I've heard what Shin has said. Thank you.
Thank you. There is another earlier question where reference was made to the Untitled virtual panel series, and where speakers suggested that pre-recorded submissions in video format can solve the problems of the parties, and the speaker. Well, I think I don't know who it is. It's an anonymous attendee, and the question is, what's the view on such issues? So I think you really can't deal with, as a tribunal, you can't just look at the pre-recorded video session of both sides and then decide who do you believe, basically, because this is not like, I don't know, Thailand's Got Talent or Philippines has got talent or something. I don't think that works. And I think Philip.
And I just add a few things. Now, if it is pre-record, firstly, I think it only refers to the submissions, say opening or closing submissions, and certainly not the cross-examination, because when it comes to cross-examination, you have to be you can't have pre-record the submissions or pre-record the cross-examination. Otherwise, we can forget about hearing altogether. Now, talking about pre-recorded submissions, even submissions, whether it's the opening and closing or other matters, for example, I think I don't like it, like you, Colin. Firstly, even virtual hearing, like what we are doing now, there is some interaction, which is important. And as already mentioned in the question, how about question from the arbitrator? He may not, the tribunal may not be very talkative, but you often find there will be some question posed, an objection from the other side and things of that sort. So all this will be lost. Now, in that case, if there is a pre-record submission, we can forget it altogether and reduce it to written advocacy. Put it in writing. It would be the same thing as far as I'm concerned. Thank you.
Thank you. And that brings us to the point about the importance of preservation of contemporaneous documents, because in this time, it's a bit more difficult to just rely on cross-examination and demeanor of witnesses. and that is why documentation becomes even more important. But interesting question from Lisa Klochenko, and she asked if there are any irreparable problems if an ARB-Med-ARB procedure arbitrator steps in as mediator, and after it is unsuccessful or not, the arbitrator steps in again as mediator, and whether any tools can be suggested to mitigate such problems. My own view is that it is quite difficult for anyone to say, you can go in as a mediator, listen, and both sides open up to you, and you hear you hear everything, and then later on, when the mediation fails, then you pretend to step in again as arbitrator, because we're humans, and you cannot press the wipe your hard disk. I think it's very difficult to do that, and that's why usually you tend to have the arbitration process work in tandem with a separate mediation process where you have a different person as mediator. But perhaps Philip and Shin can share your views on that.
I just add, Colin, I agree with you. Perhaps it's the same legal culture. I think I agree with you, and I have nothing more to add.
Thank you. Shin?
Yeah, same as I. Yes, totally agree.
Thank you. So one last question. So Robert Rhodes QC has asked, he's made the point that although there's a disadvantage of remote cross-examination, you can only see part of the witness. You can at least have a close-up of the witness's face and eyes, which you do not in a physical hearing. So I would agree with Robert on that point. You can see the eyes, and if you have a much larger screen, a 60-inch screen, then you can look, even if there's dilation of pupils, etc. But I think it's a trade-off that you get, but it is not as satisfactory as looking at the whole body, because I think the body language is more important than just looking at the eyes. It helps. It's better than nothing, but it's probably much more difficult for the arbitrators and lead counsel to try to look at whether the witnesses' pupils are dilated or not, or because you're concentrating on documents, and usually when you sit back, you look at the witness, you tend to look at the whole body, which is more important, the demeanor of the entire body, particularly the feet and where arms and general body language. Philip, what's your view on that?
Yes, I agree. As I've said, there could be further development of technology, conference technology. I don't know much about it, but I've heard people talk about 3D dimension, for example, holographic, which I've touched on during my presentation. All these things, I think, will be perfected, and perhaps it will overcome the disadvantage of remote cross-examination to a large extent. And also, if I try to tie in, Colin, with what you have said earlier, the preservation of contemporaneous documents, if I tie up together a comment which come to my mind, which I heard it many times before, people say cross-examination is the best mechanism that the law invented to find out the truth of the matter. And now I find in the past years, I've heard that no, there is a better mechanism, which is e-discovery. So perhaps if you want to find out the truth of the dispute, perhaps we should concentrate more on documents, including e-documents. Thank you.
Thank you, Philip. So I think we are now at the stage where I have to sadly draw this webinar to a close. So I'd like to say thank you very much to both Philip and Shin, and thank you very much to the PHAC staff, and most of all, thank you very much for all of you who have shown up and participated with us in this session, and for all your well thought out questions. Thank you very much. Have a great weekend ahead. Bye-bye.